Greetings. This is Attorney Della Welch, and now we are preparing for the third recording on the motion to set aside a divorce judgment. We have gone through the procedures. We talked about using the FL 300, which is the request for order form, and we also talked about how there was a motion that we use as an attachment, and items 8 and 10 of FL 300, we say see attached, and we have a motion, memorandum of points and authorities, and a declaration. Make sure that you sign the motion, the memorandum of points and authorities, and the declaration, or do one signature page where you sign all three. Then what you do is you have an original, and then you make 2 copies of the original, and then you run FL 320, which is a response form that has to be served. So your husband or the opposing side will be answering your motion to set aside, and they will be using FL 320. So it's a 2-page paper that has questions to be answered, and that has to be served with your paperwork. So go to court and put together all those papers that I have referred to, along with the blank FL 320, and go to the filing window of the court who issued the judgment. There will be a clerk of the court. After you go through security, ask to see the clerk of the court that you have a motion to set aside judgment to file. Then you go to the clerk of the court, and she will look at your papers, and she may tell you there is a filing fee. There is a waiver form if you can't afford the filing fee. And she will tell you to fill out the waiver form and the procedures for the waiver. If you can't afford it, then you would have to pay the filing fee. The clerk will stamp it in the right-hand corner section along with your conformed copies, and will write in the date for the hearing. It's often 30 to 40 days away from the date you go to the court. Make sure the date is convenient with your schedule, and you'll be given the date and the time, and make sure that that is written on all copies, and the room number and the judge and so forth. So you file all those papers with her, and she will return 2 copies to you after she keeps the original. 1 copy will be served. Have someone over 18, not yourself, that has the capacity, and they can serve, they have to be over age 18 to have capacity, to serve 1 copy of the order with the new dates, etc., for the hearing on your partner that you're moving to set aside the judgment for. And then make sure you calendar the date. And the person that personally serves the copy of the request to set aside hearing will have to fill out a form for proof of service, and that form is FL 335. That has to be filled out and signed by that person, and take that with you to court when you have your hearing on the date of your hearing. And then when the judge is there, you can ask the judge, Your Honor, may I submit on the documents I have prepared for the hearing today? That says everything I need to say. But I do have documents such as the record from my doctor or my tax returns or other documents that may support your motion. And then the other side will present their view, and the judge will order. If you're represented by yourself, you can talk with the clerk of the court in the courtroom, and she can assist you in preparing the judgment, or she herself may prepare the judgment. And then after that, you can file your answer and so forth. So, as I indicated earlier, this is a motion that has to be done with great care. I would suggest the advice of an attorney or a self-help clinic before you do this. And I hope that you have good success in doing that. And remember the 6 months time period, that it has to be 6 months from the date of the judgment that you move to set it aside. There are a few exceptions, and you can research those exceptions, but I will not cover those on this particular recording. But we hope that these recordings are helpful to you in understanding your legal rights in a divorce settlement. I recently heard of a situation where someone said, "Oh, I don't want my wife to know that our home is worth $550,000 and we only owe $100 on it, and that she's entitled to half of that equity." Well, I told this particular person, you have to be fair, that the person must make an informed decision. If you have assets, you disclose the assets. And in California, unless it's a separate property situation, they're entitled to half of the asset. If the asset increased during the marriage, they're entitled to how much the half of what the property increased. And remember, if you have a 401k, there has to be a quadro. If there's a pension, there has to be a quadro. The Army pension goes by a different name, but essentially it is joined in the divorce procedure. So I suggest the Reutter, REUTTER group in family law. They also have it in other areas such as landlord-tenant, separate books, but it's an outstanding reference. I also suggest NOLO, NOLO.com, NOLO.com as a resource. And then also you can contact your local attorneys. So this will be the end of our recording on petition to set aside the divorce judgment.